Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about a case from the BIA down as of just a couple days ago. First, let me tell you what the whole issue has been, and this has gone up and down to various courts. It deals with what is known as the 212H waiver. So basically, the way it works is, let's just say that you're applying to adjust status in the U.S. and you've committed some crime. And for argument's sake, let's say it's an aggravated felony. Okay, under most, as it used to be, if it was an aggravated felony, then you could not use a 212H waiver. And a waiver basically says that essentially you committed a crime, you know you're not admissible, but for various reasons and all the hardships shown to the qualifying relative, you are able to then basically state that you want them to forgive the crime and allow you. Well, that's what generally the waiver will be. Now, there was cases that came out basically which analyzed what 212H actually says. It says more or less that if you entered as a lawful permanent resident, then you are not eligible, basically, for a waiver if you're an aggravated felon. That's more or less the gist of it. There's different wording and so forth, but the key here in the part of the definition is where it says how you entered or were admitted, okay, as a lawful permanent resident. Now, the fact is that some circuits were essentially saying that the language on its face means that you had to have actually entered as a lawful permanent resident, meaning when you came into the United States, you needed to come in as a lawful permanent resident, not illegally, not with fraud, just as a lawful permanent resident. The BIA appeals for years has basically had a case that essentially has stated that this particular statute doesn't mean that you had to actually enter the United States as a lawful permanent resident, that you theoretically could have entered illegally, you could have later adjusted status to lawful permanent resident, and it was that later adjustment of status that created the legal fiction that you entered as a lawful permanent resident. Now, in reality, that basically means that you did not enter as a lawful permanent resident and were essentially precluded from a 212H waiver. Well, there have been courts all over the United States that essentially have disagreed with the BIA on this, and finally the BIA basically retracted its older position. It has now agreed with all the circuit courts all over the U.S. that have essentially stated that you are eligible for 212H if you did not enter as a lawful permanent resident. So there's lots of issues here that need to be looked at depending on your case. You might think you have no way of adjusting status, but in fact you might. I wanted to go longer on this video, but this is Coffee Talk, and apparently there's a whole table of people who have decided to talk very loudly above my video. So I will continue this later, but I got the gist of what I wanted to say out. It's a great ruling that just came out. So if you have questions, go ahead and call me. I'll give you a free consultation, see what we can do to help you, and then subscribe. More on the coming videos.